Okay, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every 2 weeks, telephone call for the community every other Thursday at 12:30 p.m. Eastern Time. Let me just make sure you folks can all hear me okay.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you all hear me?
Yes, sir, we can hear you.
Excellent. Okay.
The conference is now in presentation mode.
So let's begin with the frequently asked questions first. I've got a couple of them today. I mark questions that are frequently asked so that we can address them thoroughly. And this is about the age-out CSPA for children immigrating to the US. So basically, the problem is when the parents have been here 10, 11, 12, 13 years, and they are still waiting for their own green cards. The children often turn 21. The problem is, how do we get to keep them here? Can we apply for a student visa for them, an F1 visa, have them go to school? Would the F1 be denied because the parents' green card is pending and the children are named in it? So it has become quite an issue. Fortunately, as a practical matter, most of these children have been getting their F1s, and that's been working out fine. Mr. Biden has put that in his proposal to the Congress about making a law on that, protecting the children while they sort out the delays. So I combined two questions. One was from Geo and the first one was from Neil. Neil said, I'm working for a software company, 8-year-old daughter, born in India, and I've got an EB3. How can I ensure my child to remain in US? And the answer is most of these kids are turning to F1, and government are giving them F1 student visas to go to college, even if the parents are here and even if their names appear in the green card, parents' green card. So that should be okay. And Gio says, husband came to US on H1 and the children came to H4 in June 2017. Daughter was 18, enrolled in community college to transfer to a 4-year college. 2018, applied through EB5 when she was 19. Nothing moved, so she had to get an F1. That's always a good move. We did not do adjustment of status. What you mean is change of status, but she went to India and got her F1. Okay, so far that's clear. She entered the US on F1 in Jan 2020 to continue her undergrad. And because of the COVID situation, she left for India and has returned again in Jan 2021. Our petition has been approved and we would like to file for her AOS. What are the chances of my daughter's AOS getting rejected if we apply for AOS in the month of March? So the time that your, the first form 526 is pending, I believe that's counted out from the child's age. So she would be under 21 when you apply for adjustment of status in March. So you do the math, subtract from her age the time the 526 was pending, and that way she's protected under CSPA. How likely is it that India will remain current? No idea. Approximate time frames, no one can tell you. 8-9 months maybe, but nobody can give you any of these ideas. See, we are living in two realities. Pre-COVID times were different. Post-COVID times are different. As it is, times were wildly fluctuating. So who knows how much time it's going to take. Okay, very good. *5 if anyone has any follow-up questions on this sort of CSPA situation. *5. Okay, I've got one question so far. Area code 925. 925, where are you calling from?
from California, Cupertino.
Yes, ma'am. Go ahead with your questions.
Yeah, so my question was that whether we can file for my daughter's AOS was not about the aging out, but basically because she entered on F1 in January. So whether it means immediate turnaround and file for AOS, will
Oh, I
that
see.
go again?
I see. Yeah, that's a difficult question to answer. One of the choices you would have is, well, the problem is if she's entered and she's presumed, but at the same time, when she got her F1, she was already named. I don't remember how the 526 looks. Was she named as one of the intended immigrant derivatives in the forms?
So we've been understanding it as that the main applicant is my husband.
Right.
And we have given all the birth, like I think in the form we did mention about both kids and myself.
Okay. So, in my view, it is definitely a risky situation, but I don't think it's the end of the world. If I were to take a chance, I would, and if I have to go to a court over this and fight this out, I think we can convince a judge that this is a perfectly legitimate circumstance. Because, see, the most important thing is, when she entered at the port of entry, the dates were not current. Dates became current later on, right? My question, that's a question to you. When she entered the United States.
Yeah, when she entered this year?
Right, just now. When she, in January.
It's current. It's showing as current because she came in January. Yeah.
Okay, so that's a little complicated. I can't give you this answer in a group conversation. I have to go over the entire set of facts.
No problem.
You should talk to your own lawyers. I think it's risky, but it might be worth taking a risk because the benefit is so great. Overall, it's difficult to answer this question without going over all the details. Talk to your lawyers, okay?
Yeah, I understand.
Good luck.
Okay, yeah, okay.
All right, bye-bye.
Yes, thank you. Bye.
Okay, let's go to, I don't know what I did with area code 925. Let me just go to you personally. Area code 925. It looks like I already unmuted you. 925, can you say hello? Or maybe you were the one I was just talking to.
I just
okay.
spoke to, I just spoke
Yeah,
to
I
you,
think I just screwed somebody up.
You can mute me again.
1 second. Yeah. Okay, could you please raise your hand again? Press *5. I kind of muted you. Sorry. Press *5. Okay, got you. Area code 815. Go ahead, please. Where are you calling from?
I am calling from Iowa.
Yes, sir.
So my question is about, I am actually on a EB2 and I downgraded to EB3.
Right.
And I actually included my son in AOS.
Right.
And he's attending college. So now we also applied for EAD. Is it okay if he uses the EAD? And if he turns 21, it will become a problem for him?
No. Wait on a second. Let's get the facts straight. So your son is right now under 21, correct?
Yeah, he's 18 years now.
Okay, good. You filed a downgrade to EB3, correct?
Yeah.
When you filed the downgrade, his dates were, of course, the dates were current. He's under 21. You file the time that the 485.
Not current. We filed using the filing date, not the final action date.
Okay. So here is the problem. The problem is, first of all, if the final action dates don't become current within the next 3+ years, your son would not be able to take advantage of the age out. Now remember, the age out thing is definitely on the examination block. by the current administration. They don't like the fact that children are aging out. The recommendation made by Bernie Sanders and other people who were examining these facts, I think the recommendation was that the children should never age out. Okay, so I think the laws might change, but if the laws do not change, the complication is that the only time you can subtract from his age is the time the I-140 remains pending. Okay, so therefore, if the final action dates don't become current over the next 3 years, you could have a problem. And the problem is simply this, that you would have to apply for him separately when you get your green card, and you would apply it as US green card holder or immigrant applying for unmarried son. Okay, so that those are sorry, the priority dates don't matter because that'll be a different category altogether. It won't carry these priority dates. Those will be family-based priority dates. Okay, so the first,
question is,
you can't do much about it.
go ahead, sir.
You can't do much about it. You've got to wait. And two, the laws might change. And if the laws still don't change, you've got the third option for applying for him separately. Okay?
The question is, if I use the EAD or not using EAD, is there any advantages? Because
I don't.
You want to do something.
Yeah, I don't see any advantages in not using the EAD, because look, if he's got a career opportunity, I would use it. He falls out of F1, but so be it. I'm okay with that. I would take that chance. Okay?
Because I was telling that after 21, even he may not get F1 because he already applied for AOS.
Well, they still might give him an F1. I've had cases where they gave F1 even with 485 pending. So I'm not that worried about that part. I'm worried about his immediate opportunities. If he's getting good opportunities on EAD, go for it. I think it's worth a shot. Okay?
Okay, sir. Thank you.
You're welcome. Good luck. Okay. I think, I'm not sure. Another one? Area code 518. Where are you calling from?
Hello, I'm calling from Fairfax,
Yes.
Virginia.
Yes, sir.
First of all, thank you for this great opportunity for
Of
all of
course.
us to listen
Of
to you
course.
and get insight.
My pleasure.
But since we are on the topic of children aging out, I thought I will check with you on this.
Sure.
Myself and my wife, both of us are we applied for naturalization back in last year March, just before the lockdown came. And for whatever reason, it took time, and now we both have interview appointments coming up in next month.
Right.
My son, who was 17 when we applied,
Right.
is now 18.
Right.
He turned 18 in December.
Right.
So the question is, will he get naturalized when I get naturalized, or
Okay.
now since he is 18 plus, he has to apply N400 separately?
I do not know the answer to that question, but the answer should be very clear from the USCIS web pages. This is such a tertiary issue. I don't deal with it all the time, so I don't know off the top of my head. Okay. Sorry.
No, it might be. Whatever I read, the confusion I still have is, do they consider the age at the time of naturalization of parents, or is it at the application age? That was my confusion.
What I would suggest to you, sir, is a very practical solution. Just contact your congressman and ask them to find that out for you. It will take them less than a day to get you the answer. Okay.
All right.
So, yeah.
Thank you so much.
That's easy enough. Sorry about that. Good luck.
Thank you.
Bye. Okay, so now I think I had another, here's another frequently asked question, and this one is actually coming up quite frequently. When do I file supplement J? Can I stay without working when my 485 EAD has been issued, but I don't want to work, or I don't have work? If an H-1B is denied, does it have an effect on 485? So Mohan says, I'm currently on H-1B visa. My priority date is this. I'm working for employer A, applied for adjustment of status. In October, both EAD AP are not approved. No biometrics yet. So the question is, if I change to employer B after 180 days, how would USCIS know that I changed my employer if I do not file 485J? They probably will not know unless the employer A revokes the I-140, and that's okay if it is done after 485 has been after it's been 180 days. They'll probably send you a notice of intent to revoke, and you can send a supplement J, and that should take care of it. So how would they know? Usually if you do an H-1B transfer or if the I-140 is revoked, that becomes their source of knowledge. After getting EAD, can I stay without working for a few months? Absolutely. The regulations only require that when asked, you should be able to produce an offer of employment, not an employment, but offer of an employment for a same or similar job and file supplement J when asked. But if you don't get asked, there is what you do in the meantime. If you just want to bum around, that's fine. You want to do something completely different, take a course, all of that is okay. But when the government asks you for it, you should be able to provide an offer of employment. You can stay without work for as long as you want. I'm working for a consulting company, change my client, not within 50 miles. Current employer is not planning to file H-1B amendment. You are not considered to be in legal status, and I keep telling people it's not 50 miles, it is normal commuting distance. That's the standard for H-1B. And normal commuting distance can be more than 50 miles. In New York, New Jersey, we have one cases with 70, 80 miles commuting distance. That's beyond 50, well beyond 50. So I do not know exactly what your situation with this employer is. Unless you have changed over to EAD, there can be a site visit and there can be a notice of intent to revoke your H-1B. But what do you care? You're not doing anything illegal. Basically, you're working on your EAD. So if you have a 485 pending, you're always allowed to stay in the United States. But make sure that you have an EAD. Because if you don't have an EAD and you're working off-site, that could be considered unauthorized employment. It could become a problem for your 485. A denial of an H-1B does not directly affect the adjustment of status. Unless the denial is for a ground that can touch your green card, there's a fraudulent degree or the employer has committed some fraud. So normally an H-1B denial has no effect on the adjustment of status 485. Okay. Any follow-up questions, guys? Star 5. Any follow-up questions? Press star 5 on your phone. Okay. So the first one I have is from area code 817. 817, where are you calling from? 817.
Yeah, hi, I'm calling from Texas.
Yes, sir. Go ahead, please.
Yeah, hi, Rajesh. Thanks for answering the question.
Of course.
So for the third question, bottom line is that you're saying that if there's a site visit and if something happens to the H-1B, still am I considered in legal status?
My only concern is, do you currently have an EAD or no?
No.
Okay. My concern is that then you're working without authorization. And if you work without authorization, that can affect your 485.
No, I mean, if there's a problem and if I don't work, if there's a problem H-1B because of site visit.
Yeah, you can choose. Yeah. You can choose not to work. That's fine. Okay. You can choose not to work.
For example, if there's a problem on it. Okay.
Yeah, but you should stop right now. Don't work without authorization at all. Okay.
Okay. No, it did happen, but I'm just asking in case.
Yeah. You should just quit and say, I'm going to sit at home. Unless you file an amendment, I'm not working. Okay.
Oh, got it. Okay. And then one other question is that once I change the employer to employer B, at what point do I need to file 485? Like within how many days do I need to file?
Not for you mean supplement J, right?
Yes.
Yeah,
Sorry,
not for
J,
you.
yeah.
Yeah. So supplement J should be filed. See, it is not required right away. There's actually no time limit on it. But I usually file right away as soon as I know that somebody is going to stay with this employer for a long time. I move to file 485 supplement J as soon as possible. Otherwise, they end up sending notice of intent to revoke. Then we respond. Just additional paperwork. It can be avoided if you file a quicker supplement J. Okay.
Okay, thank you.
You're
If there's an intent to void, within how many days do I need to submit?
If they send an intent to revoke, or actually intent to deny in this case, I think they give you 10 days or 33 days, one of the two. I've seen different times for different petitions. So either 10 plus 3 or 30 plus 3. No problem. Good luck. Area code 781. Where are you calling from?
Yes, I'm calling from Boston.
Yes, ma'am.
Yeah, thank you so much, Rajeevji. This is really helpful. You don't know how much stress we go.
Oh, no, I know. I was on the other side. I was in school and I paid an immigration lawyer $60 for consultation. That was my 3 weeks grocery bill. And the guy knew less about immigration law than I did. So that was very disappointing. No, I know how you feel.
Yeah.
So
thank you. So I have one question. So I'm currently on my F1 OPT and I have a job with the university.
Okay, normally, hang on. This is your first time calling. I don't take unrelated questions to questions that I'm discussing so that we can keep the discussion modularized. But since this is your probably first time calling, that's okay. We'll make an exception for you. So you're on OPT. Now what happens?
Yeah, so my apologies, I did not know
That's
that.
okay.
But yeah, my university is willing to do a J1 research scholar visa for me.
Mm-hmm.
But my OPT runs out in July.
Okay.
And I have only 6 months to change the status from F1 OPT to J1. My J1 starts in July. So I'm wondering whether I should do a change of status here or I go to India and get a new stamping done. Now India, my only issue was,
you can go to any country.
I don't know if I'll get the appointment.
Ma'am, you can go to any country. Don't have to go to India. See, once you get your F1 stamping once, the issue of your intent to remain permanently in the United States has been examined, and the third country consulate may be willing to grant you the J1. So you can go to probably Mexico or Canada, whatever consulate is open. Okay.
Oh, I see.
Yeah, that seems to be. Yeah.
And
that seems to be of better advantage to you than applying for change of status, because that could take so long.
Okay, that's correct. But I don't have visa, so I'll have to explore that. I don't have Canadian visa or Mexican visa to enter.
Canada, you need a visa, but double check. I don't know Mexican laws. My understanding is if you are coming from the USA into Mexico, you don't need a visa.
Oh, okay.
Okay.
Thank you for that. I didn't know that.
Yeah.
And if I file a petition, just one very quick follow-up is if I file a petition and I don't get approval by July, and then I get appointment with Indian consulate, can I cancel my petition?
Oh, yeah.
Abandon it
Oh, yeah. Absolutely.
Take appointment in India?
Absolutely. That's done all the time.
Okay, so
You actually don't even have to cancel. By the sheer act of leaving the United States while your case is pending, the case is deemed to be denied. So you can send a letter out the day you are leaving. That's fine too, just to keep the record clean. But yeah, that's very easy. People do it all the time.
Mm-hmm.
Okay.
Okay, and then under the same DS-2019, get a new visa appointment with the consulate. So,
I don't know those tertiary details, how you do, what DS you would be using. But as far as applying for a visa while the petition was pending, that's perfectly fine. No problem with that. Okay?
okay.
Good
Thank
luck.
you so much.
You're welcome. Okay, getting back on track, guys. I just had 2 frequently asked questions marked out. Rest are our regular questions. So let's go to the first one. There was a mistake made. Ria says, made a mistake on 765 where I said I did not check that I understand English, etc., or I don't remember, and USCIS said you can send a letter. I don't know the answer to this question. Because USCIS will send back, and we had, this year it's been awful. We made a couple of mistakes in our own I-485s because we filed so many. One case we send in an I-140-485 downgrade with the signature page blank, and that's gonna get returned. Nothing we can do about it. Our client lost their chance. But that will happen when you do a lot of paperwork. These things can happen, but government will forgive certain mistakes, but they will not forgive certain others. Like, for example, filing fees mistakes. I think there's a question about that somewhere. Filing fees mistakes, they don't usually forgive, as far as I know. And signature mistakes, they don't. This one is somewhere in between. So, Riaz, I can't really predict how it's going to go. No harm in trying to send a letter to the USCIS and see how it works out. Okay. So, if there is a possibility of refiling, if you are still within that time frame, refile. If not, send out the letter, see how it works out. *5 if you have a follow-up question on this. *5. Okay. Let me go on to the next question. This is question number 3. I-140 is withdrawn before 180 days of pending 485 and EAD. If I-140 is withdrawn before 180 days, government thinks of the whole case cancelled. So if the I-140 is withdrawn before 180 days, the whole case is gone. So are the EAD. Everything is gone. But if you have already used the EAD, during the time you had the EAD, it is not illegal to do so because you thought you had a valid EAD. But the moment the denial comes, you have to stop using it. But the time that you already spent using it, it doesn't get charged up against you as a negative factor. Yeah, I think I covered all your questions. If you have a follow-up question, press *5. Question number 3, IT Pro. If you have a follow-up question. Okay. So this is from a person, a Canadian citizen, who through some problem was stamped WD7A1. I looked it up. The WD7A1 stamp is just basically a stamp that says this guy wants to live in the United States permanently. So coming as a tourist might be difficult forever and ever and ever, but it's worth trying. So you can try once when you truly want to just take a trip to the United States. And if they still return you at the airport or the border, I presume you will drive, then you know the answer. At that point, you would have a chance to try to re-agitate the issue through opening what is called a TRIP inquiry. TRIP, so just Google CBP TRIP. I forgot what the program is. I think it's Travel Redress something. So it's a program under which you can ask them to reconsider certain things and present your side of the story. Government will then keep that story online. So the Customs and Border Protection officers at all the airports and land borders can pull up that data and see that they already have basically gone over the paperwork. So you should be okay. So try coming in. If it doesn't work, just see if a TRIP inquiry works for you. Okay. *5 If there's a follow-up question, press star 5. Next question is from number 5 is Rick. B2 visa duration and extension. They have a couple of follow-up questions. Can a B2 visa holder return back to the United States within 6 months of their leaving? Probably not. Because if you are spending more time in USA than you're in your own country, government can take the position that you are actually living in USA and visiting your country. So yeah, they can create a problem with that. I've applied for a B2 extension. It's still pending. Can I leave and come back within requested extension period? Probably not. Because if you leave when the extension request is pending, the extension request is deemed to be abandoned. It doesn't exist anymore. So there's no question of coming back on it. Star 5 if you have a follow-up question. Star 5. Okay. I just answered this question about a US passport for Section 320. I do not know the answer. What I would do is I would just Google Section 320 USCIS, and that will bring you to a page. I've done this a few times. It will bring you to a page that contains all the information and all these little permutation combinations. The child must be this age, you must be here, there must be custody. All these issues are on that page. Okay. So I don't have much else to add to that. Next question is number 7, Akankshi Shah. Wait for H-4 EAD or convert from H-4 to F1. Finishing graduate degree online. So should I go to India to get my H-4 visa stamping? No. Or F1 visa. Let me see what you're saying. Oh, okay. So you hung out with us at UD's. Okay. All right. I want to share my background. Came to USA in May 2018 on F2. In 2019 changed to H4. Studied on H4. Okay. I'm not sure which way to choose for H-4 EAD or convert my visa from H-4 to F1 by going to India. So I guess you want to convert to F1 because you want the OPT. The post-completion optional practical training, I guess. So my H-4 visa is on the paper but not on my passport. It is still on F2 visa. So will there be any issue that can occur at the visa interview? No, because when you do a change of status, that's exactly how your paperwork looks. So if you were in USA on F2 status and then you did a change to H4, your passport will still carry F2, no problem. If I got my F1 rejection, can I apply for H4? Yes. Any chance of H4 rejection? No. Just because an F1 is rejected, H4 cannot be rejected on the same grounds. The only thing I would make sure is just be very truthful with the government. Because if you tell a lie and get caught in it, that's a permanent bar from getting any kind of visa. Now all classes are online. So how to tackle questions, like I can study from my home country, as everything is, just tell the truth. There is really, the bottom line is very simple. I am going to school. I go to school online right now, but ultimately I'll be returning to classes. And my husband is in USA. Of course, I want to live in USA. So I mean, just be honest. Don't try to make things up. Star 5 if you have a follow-up question. Star 5. Yeah, I don't think there should be any chance of rejection of entry into the US. That's unlikely. Okay, next question is from a fellow lawyer, Abhishek Deswal. F1 stamped for 5 years, 1 year graduate course. Okay, so Abhishek, the way this works is, the stamp on the passport is simply a method of coming and going. It only allows you to come to the US border. So you get into a plane and you can come to the US border, but how long you can stay is based upon your I-94. So if your time period is only 1 year, your I-94 will say 1 year, you'll have to return after that. You cannot stay 5 years just because your visa allows you to. Okay. Star 5 if you have a follow-up question. Star 5. All right. Move on to question number 9. applying for a re-entry permit after receiving green card. So the way it works is you can actually apply for a re-entry permit immediately after you get your green card. There's no cooling period. You could do it the very next day. Many people do. But there is a logistical issue that if you leave after, you have to be in the United States when your re-entry permit application is received by the government. After that, you can leave. But then you'll have to come back for biometrics. After that, you can leave again. Or you can come to the United States, request an expedited biometrics, which they are not giving these days, and leave after you do your biometrics. Then once the advance parole is approved, or re-entry permit is approved, it will be delivered to your address of choice, whether in your home country or in USA. Okay. *5 if you have a follow-up question on this. *5. Okay. Question number 10. USCIS Receipt Notice Delays. Yeah, that's normal. That's normal. So we are now getting receipts, just beginning to get receipts of cases we filed in October. This is I-140s, 485s, all those cases. Okay. There's no follow-up question on this, obviously. There isn't anything more to say. Question number 11. H-1 H-4 EAD is expiring. H-1 extension is already filed. Assuming H-1 H-4 EAD expiring in April, H-1 extension already filed, isn't it a good idea to apply for H-4 visa from outside USA? Get an appointment for the earliest when the appointment. Yeah, some people are telling me that's working better. Okay. And I wasn't sure, and I checked with our team. Apparently, if you get your H-4 visa and come back, you do not have to go for biometrics, and that saves a lot of time. So that's what I'm hearing. You guys are more creative than I am many times. So that's what I'm hearing too, that because it saves time on the biometrics, that ends up being a faster option for H-4 EAD. Okay. The only thing is you are going to have to go to the consulate, and that may not be much of an issue. If you are doing Dropbox, they seem to be working just fine. *5 if you have a follow-up question. B2 extension, this is number 12. B2 extension and RFE response for parents during COVID. My parents were visiting USA last year. We filed for 539 due to COVID. Okay, so my father's application has not been responded yet, but my mother's has received an RFE. So I don't understand, are they still in USA or have they left USA? If you're on the phone, press *5. Okay, I don't know what the exact situation is. So let's see if we can cover it. In RFE, USCIS asked us to prove that there was an attempt to leave USA and prove intent to depart. What document should be provided? Well, the answer is very simple. You only can have documents of that which was done or true. Okay. If you don't have a document, just provide a statement. We had submitted a statement. The reason you provided appears to be a general statement. Okay, so what they are asking you, and this is what they have done in many cases, what they are saying is, it's not that you want to leave and you cannot leave. You have to prove that you want to leave and you cannot leave. And the answer is no, that's not our case. We didn't even try to leave because from what I understand from what your questions ask, we just wanted to stay here to be safe. And that is the reason we stayed back, to extend our, and make sure you add those words somewhere, that to extend our leisure and visit with our family. So this was a question of choice made due to caution. It was not our inability that caused us to leave. So this question is irrelevant because that's not the situation. Yeah, don't try to prove that which is not true. The truth is there were flights available, but you were not comfortable sending your parents out. That's fine. Yeah, you can financial resources, you can always tell them. You can even submit, I think it's the form I-131, or you can say that you would, just in a letter, you can say that they are my parents, of course I will take care of them. So you can give your own statement in support of that. There is no illegal extension here because, see, as long as an extension is legally pending, you don't accrue any unlawful presence. Only when the case is denied, the unlawful presence begins. Okay? I don't think you are here. Star 5, if anybody has a follow-up question on this. All right. Let's go on to question number 13. Applying for H-4 after marriage with an approved I-140. Well, remember, for H-1 and H-4, the fact that a green card is pending is no bar. There's no it's a dual intent visa. Immigrant intent doesn't bother us. Your first question is there a risk of me being denied H-4 due to immigrant intent? You always tell the truth. Never try to hide anything. Okay? So dates are current, not current, doesn't matter. H-4 visa is not hurt by immigrant intent. If I-140 is approved by the time of marriage, would you recommend we go with just H-4 or H-4 EAD as well? I think you should always do H-4 EAD. I don't think it really slows anything down. And of course, we just talked about that. Get an H-4 visa, come in, and then apply for an EAD. Somebody just raised their hand. I'm not sure what that is about. I'm still talking about this case. Give me a minute. What would you recommend if her priority date become current by then and she filed the I-485? Yeah, of course. Look, you can have EADs going in two categories, under H-4 as well as under I-485. My current employer might soon file an H-1B. They are waiting for the rules. If the H-1B approval comes before my H-4 visa appointment, can I still go for H-4? You can, then later for H-1B, you can. But if you go for H-4 visa stamping, come into the US, you'll have to apply for change of status to H-1, which is like refiling the whole case. So I don't know the answer to this question. Probably I would come in on an H-4 and then do a change of status. And no, H-1 doesn't get cancelled if you come on H-4. If the H-1B approval comes after I get the H-4 visa, does the H-4 become cancelled? No, there's no last action rule. Whatever visa stamp you have is good. Now this is the hard part. I'm not sure I have a good answer to this. Can I apply for H-4 to H-1 change of status immediately upon entry? I think I would. I think it's okay to do that. But I can't tell you that I have 100% guaranteed ironclad excuse for that application. Normally within 90 days, if you try to change status to work status, government can take an objection to it. But especially when you file your DS-160, you can actually point out to the government that I want to work in the United States. And if they ask you, you can tell them only if legally allowed. I think if you have made that representation in your H-4 application, and then if you apply for an H-1 right after you enter on H-4, I think you're pretty safe because you declared your intention. That's my feeling. Okay. Let's see. Anybody has any follow-up question on this? Press star 5. Area code 210. Where are you calling from?
From Texas.
Texas?
For taking this.
Yes, of course. Go ahead.
Yeah. So, what you said about whether we can go ahead with just the H-4 or the H-4 plus EAD.
Yeah. See.
My confusion is that.
Yeah, go ahead. I'm listening.
Sorry.
Yeah, go ahead.
So, would we have to be physically present in the US?
Yes.
With the EAD?
Yes.
Do that from
Yes.
The H-4
No.
plus
You cannot do it from outside the USA. I was answering the question, if I have a choice between applying for H-4 and EAD from inside USA or going outside USA, getting an H-4 stamp, and then come back and apply for EAD, I would take the second one. But if your question is, can I apply for EAD while she's still there? No. She has to be in the United States.
Okay, got it.
Okay? Good luck. Okay, let's see. What did I just do? Let me see if I can get to area code 847. 847, I think I have you unmuted. 847? Hello? 847?
Yes, hi Ravi sir.
Yes, sir. Illinois? Go ahead.
Yes, Illinois. Sir, I think I have a question related to follow-up, I think with the previous one or this one. My question is with my H1 was recently approved with a new employer.
Okay.
H4 is extension is pending.
Okay.
H4 EAD is about to expire in 4 months.
Okay.
So can we file for H4 EAD extension or should we wait until H4 extension is approved? it's taking long.
Yeah,
So
okay.
It's not done for H4.
Okay, let me understand it one more time. So, you currently have an H4 valid till what month?
H4 validity is until August this year.
August of this year. So, a good 8 months from now. Okay. No, 6 months, 7 months from now. Okay. And when does the EAD expire? July. Okay. So now you know that you can't apply more than 180 days ahead of time, right?
Yes.
Okay. So the EAD you can't apply more than 180 days ahead of time. H4 if you do, they'll just give you lesser time on the H4, which is okay. You lose a month. That I don't think is the end of the world.
H4 extension is already applied and pending because my H1
so they did it.
and
Okay.
H4 was filed together.
Okay, got it. So I think EAD extension,
H4 EAD is
yeah,
expiring in July.
it cannot be applied more than 6 months ahead of time. If we are already in that time frame, you can apply for the EAD now, no problem. You have your receipt, right? H4 receipt?
Then H4 receipt is there. Yes.
Yeah, you can apply for your EAD, no problem. Do it.
So then if because H4 extension, it's taking like almost up to 1 year to get approved. In that meantime, then if July comes, does the H4 have to stop working?
Yes. The only EAD that allows you to continue working is the 485 EAD and of course the OPT STEM extension. H4 EAD has to stop working. Okay.
Okay, thank you so much.
You're welcome. Good luck. Okay. I have next one is area code 210 Texas. Yes, Texas, go ahead please.
With regards to what you just said on question 4, so
question number 4, that was like 6 years ago. What are you talking about? Hang on. Question number 4 was like an hour ago.
Bullet number 4.
Bullet number. Okay. All right. Bullet number 4. My current employer might soon file an H-1B for me if the H-1B approval comes before my H-4 visa appointment. Oh, yeah. Okay, go ahead. What is the question then?
So in short, my question is, if you hold both a H4 and a H1, while traveling to the US, so can we wait until that point in time to decide which one we want to enter?
Okay.
Does it depend on which one we provide at the port of entry?
All right. First of all, practice and theory. Theoretically, before the consulate issues another visa, they are supposed to cancel all existing visas. Okay. But as a practical matter, they never do it. So if somebody has an H4 and an H1 and they are traveling, I personally don't think there's a problem with presenting either one at the airport. You can say, okay, I want to come on an H1B. No, I want to come on an H4. So I think it's okay.
Which one would you recommend?
If she has a job, look, if she has a job, I would definitely want to come in on H-1B, not an H-4.
Okay, versus coming in on H-4 and then applying for a change of status.
Change of status is like reapplying. That's like reapplying the whole case. They can reopen the whole case. Don't do that. If you can avoid that, don't do it.
Oh, I see.
Okay.
Okay.
Good luck.
Thank you.
Bye. Because see, H1 change of status is not like a normal change of status. It's like reapplying the whole darn thing. Let's say question number 15. Hey guys, we're not going to have a lot of time for new questions. I have to leave in about 11 minutes. So moving to H1B from adjustment of status if currently working on EAD. So if you are working on EAD, your H1B is suspended. Two possibilities. Your H1B petition is valid and you have a visa stamp. Very easy. Go outside USA, go to Mexico or Canada, come back using your H1B. You are back on H1. Okay. But if you don't have a petition approved and you don't have a visa stamp, then you got to get both of them done. When you return using your H1B, you are back on H1B, no longer on EAD. So it's perfectly reversible. Just have to step out and step back in. Star 5 if you have a follow-up question on this. Okay. Let me go to question number 16. L1A stamping in Canada instead of India advantage. Oh, advantage is just it's a lesser time. We do a lot of our cases out of Canada, and I think Canada is just fine. And if you were on something like a tourist visa, etc., I would have to probably consider carefully. But you've been here on an H1B. I personally don't think that going to Canada is a bad option for you. Star 5 if you have a follow-up question. Star 5. Okay. And the last posted question is number 18, employment-based question, EB2 I-140 approved. We did the downgrade. Oh yeah, the fees amount. The fees amount was incorrect. Man, I feel sick about this. Our office has made mistakes too. A couple of petitions we spotted. I don't know if there are more. When we file hundreds of cases, it can happen no matter how careful we are. But I think if you have the wrong filing fees, it is very unlikely they are going to allow you to file it again. Very unlikely. I hate to tell you that. Yeah. Okay. Star 5 if you have a follow-up question on this. Star 5. Okay guys, anybody has any question, press star 5. I'm going to try my best to answer the questions that we can in the time I have. Star 5 if you have a follow-up question. Anyone? Okay. Area code 503, where are you calling from?
I'm calling from Portland.
Yes ma'am, Portland, go ahead.
Yes, so my sister's mom is here on a B2 visa, a visitor's visa, and I'm trying to see if I can apply for a student visa for my sister. And what is the likelihood of
almost always a bad idea. Okay, there are people who've done it successfully and their cases have gone through smoothly, but normally when you try to change from B2 to F1, even if the USCIS gives you the F1, if you try to travel outside USA, the consulate will almost never let you come back. They'll say you lied to us because you told us you were going to go for a short trip and now you've gone for a long-term visa. So you have two difficulties. USCIS itself could refuse to do it, and consulate, if you ever go for a visa, will create a lot of problems. So usually not a good idea. Okay?
Okay. So I'm trying to keep him here because of a domestic abuse situation. Do you have any other recommendations? I want to keep them legally. Do you have any other recommendations?
Domestic abuse is in India?
Sri Lanka.
Sri Lanka. I don't know of any visa when the abuse is outside the United States, ma'am. Okay, sorry.
Okay, all right.
Good
Okay,
luck.
thank you.
Bye. Area code 518. Where are you calling from?
Hi, I'm calling from New York.
Yes, ma'am.
My question is my visa, my application is in a national visa center currently,
Okay.
but I'm in USA. So how do I notify them that I don't want to pay the fee for NVC and go through USCIS? They have answers on frequently asked questions, but they're very unclear. So if you can please guide me through.
Okay, so let's understand this. Are you in a family-based category or an employment-based category?
Family-based category.
Okay. Is your husband in the United States?
Yes.
Okay. Are they a U.S. citizen or a green card holder?
No, they're not. My sister filed for me, and she's a naturalized citizen.
Okay. Are your priority dates coming up soon?
No.
Okay.
It's
Okay.
in 2013.
Okay. Has your sister received any paperwork from the NVC?
No, I actually received email from NVC.
Okay. When in doubt, always go to your congressman. That's what makes the most sense. So once you are unclear what you're supposed to do, they are not very clear, just contact your congressman's office very quietly. Just tell them, look, I am your constituent. I live in this area. I have this problem. Can you please contact NVC for me and let them know we don't want to go forward with this application through consular processing? And that should take care of it.
Oh, okay.
Okay.
Is it going to be a long process or?
Oh, no. Oh, no. Yeah. The congressman's office can get things done within a couple of days for you because they have an inside line to the consulates and the NVC.
Oh, okay.
Okay.
That's helpful.
Yep. That's what I would do.
Thank you so much, Archie.
You're welcome. Good luck. Guys, today has been a very interesting day. I just had 2 extra questions. Usually there is a bunch of us, but that's perfect. Now I can leave and you guys have there is still one. I spoke too soon, I guess. 1 second. Texas, go ahead. Texas.
Thanks, Rajiv.
Yeah.
The question is this question is on behalf of my fiance. So she's in India and she has an approved I-140. So the question is, these hike in wages, these new wage hikes, do they apply just to new H-1Bs that are filed through the lottery? Or do they also apply to cap exempt H-1Bs?
Yeah, I'll give you the simple answer. She's not going to have any problem. I can go into the details, but the simple answer is that's not going to be a problem for her. Okay?
Okay.
Good luck.
And the second thing is, she has like you said, she has I-140 and the dates were current in October based on the filing date chart. So it was current based on the filing date chart from October to December, but not subsequently. But their employer didn't file I-824 for her. So my question is, can they still do that, or do they have to wait for the dates to be current again?
Yeah.
Either the final action or the
wait. Look, from what I remember,
just the I-824.
Yeah, from what I remember, they were not accepting I-824s until the dates were current. This is not written down anywhere. So just remember that President Biden is completely revising the procedures. If this procedure is not changed right now, it will be changed within the next 6 months. Okay. So it used to be that you could file I-824 at any time. So first thing I would do is, since these are not procedures written down, keep track of how things are working out. You can keep track of my Twitter feed, my LinkedIn account, my Facebook, or our immigration.com website. We post any changes in the government instructions. You can also call the USCIS, find out if you can file the I-24 without the dates being current. Okay. Personally, I think it's a ridiculous idea not to be able to file I-824. So double check and expect this to change anyway. Okay? Good luck. Okay, guys, so we did exactly bang on 1:30. I will see you guys again in 2 weeks. It's always a pleasure talking with you. Take care, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.